Well, good morning, good afternoon, or good evening, wherever you are, and welcome to our discussion about dividing retirement plan assets in a divorce, a subject that sometimes eludes both the divorcing couples and their advisors. The retirement plan assets, believe it or not, usually are the first or second largest asset in the marital estate. So what we want to do today in the next 45 minutes or so is to describe to you the most important issues that come up when divorcing couples deliberate with or without their advisors on how to share retirement plan assets. So let's go to the first slide. Well, we have to go, well, can we go back one? Okay. Let's begin by exploring all of the different sections of retirement plan assets, the different categories. The overriding categories are called defined contribution plans versus defined benefit plans. And the sub-elements of each are as follows. I'm sure all of you have heard of 401k plans. 401k plans typically are funded with employee money on a tax-deferred basis, and they will include employer money if there is a match or if it's combined with a profit-sharing plan. Profit-sharing plans are typically funded solely with employer money, so that when you combine 401k plans with profit-sharing plans, you have employee and employer money combined in one type of trust fund. The pension plan area is the defined benefit plan area, and that section has two sub-elements. We have what are called cash balance plans, and we have defined benefit plans. Cash balance plans are defined benefit plans that are communicated to employees in accounts, very much like 401k plans are. Defined benefit plans, on the other hand, are communicated to employees in terms of benefits. So throughout this presentation, we're going to be talking about dividing accounts, which are typically defined contribution plans, or we're going to be dividing benefits, which are typically defined benefit plans. Next, we have 403b plans. 403b is the 401k cousin, which is adopted mostly by tax-exempt organizations, primarily schools and hospitals and nursing homes for employees. And it contains both employee and employer money. And 403b plans have another wrinkle in that they are either called ERISA plans or non-ERISA plans. ERISA plans must follow all the rules applicable to qualified plans, and non-ERISA plans, which typically contain only employee money, are not required to comply with most of the elements of requirements for qualified plans. 457 plans, another cousin of 401k, is adopted by states and local governments for employees, along with certain tax-exempt organizations. And it defers employee money, typically funded fully with employee money. So those first bullets are, for the most part, all of the plans that come up in qualified plan sharing when it comes to divorce. There are, of course, one other area that we must discuss, and those are called SERPs. These are non-qualified plans. SERP stands for Supplemental Executive Retirement Plans, and they sometimes get involved with divorce, especially when an individual has several retirement plans, both qualified and non-qualified, and we'll talk about them later. Visibly absent, however, from this list are individual retirement accounts, or IRAs. We'll talk about IRAs later because they have a different set of rules when it comes to splitting retirement plan assets in a divorce. So let's go to the next slide and begin the discussion. There are two important documents that advisors and deliberating divorcing couples must address when the divorce is imminent. The first is called the Property Settlement Agreement, or the PSA. The Property Settlement Agreement will describe the how and the when all assets in a marital estate are to be divided. And that will include retirement plans, it will include the home, the jewelry, it will include everything that is owned by the couple in the marital estate. And we'll talk about how PSAs should be drafted for qualified plans a little later in this presentation. The second most important document that is important to divorcing couples and their advisors is known as a QDRO, Qualified Domestic Relations Order. Qualified Domestic Relations Order is an order entered in the court, and it takes its stipulations from the PSA regarding only the retirement plans. A QDRO begins as a DRO, a domestic relations order, and it must go through some hoops and whistles in order to become a QDRO. And we'll talk about that a little later too. So we have an order that codifies the retirement plan provisions of the PSA. So here's an example. Let's say we have a very simple division. We have a 401k plan. The QDRO will state the how and the when the QDRO account will be split between the two parties and when the distribution will take place to the non-participant spouse. That could be as soon as it's drafted, as soon as it's entered in the court, or it could happen later when the participant gets his distribution. So let's go forward. When do we divide the retirement benefit or account? 4 very important choices, and all will have very, very different results depending on the choice. We could use the date of separation as the date that we will allocate the account or the benefit. We can use the date of the complaint, which is typically the date that the parties file for the divorce in the court. We could use the date of the divorce. Now, from the date of the complaint to the date of divorce, from my experience, could be as short as 1 month and as long as 7 years. My experience has been that the divorcing parties will agree almost quickly on everything but the retirement plans. And the why is because the retirement plans are the first or second largest asset in the marital estate. The last choice, an important choice, is we don't divide the marital assets retirement plan until the benefit or account commencement happens at some point, sometime in the future. And as we will see later in the examples I provide to you, there are significant differences between each of these dates, especially the last one. So let's go on to the next slide. There are 2 basic dividing methods that actuaries and others in the business of dividing retirement plans will use in dividing retirement plan assets in the marital estate. The first is called valuation and offset. Here, much like we would value the home or the jewelry, the valuation is assigned to the retirement account or the retirement benefit. And that amount is offset against other assets in the estate. So I'll give you an example, probably an exaggerated example. Let's say that the couple own a home and the husband has a retirement plan. And these are the only two assets in the entire marital estate. And after doing calculations, we find that the home is worth $500,000, and the retirement plan account or benefit is also $500,000. So if the couple adopts the valuation and offset method, the two offset each other, and the husband would keep the pension and the wife would keep the home, and they're done. That's an exaggerated example, and some better examples will come later in this presentation. Now, when the valuation method is rejected because it just doesn't work, or because the actuarial assumptions used to value the retirement plan are either in the minds of the divorcing couple or the advisors inaccurate, then we go directly to what we call the order, the quadro, the DRO that becomes a quadro later. And the quadro, as I said before, provides the how and the when, and it also describes what happens till we get there. So if we have an example where the quadro says the non-participant spouse gets half of the participant spouse's account in the 401k plan when he gets his share, we must describe in the order what happens between now and then. One or both of them could die, the plan could terminate, amongst other things that could happen. And we must describe and stipulate what happens in the order so that there's no question that the division of the retirement assets will be proper and accurate. Let's stick with defined contribution plans first and go to the next slide. When we have a defined contribution plan, we have accounts. And there are two different situations that will occur in the divorce. One is where all of the money in the account evolved during the marriage. The second is the one participant who has the account came to the marriage with an account in place. So let's look at the first one. If all of the account evolved during the marriage, we have an easy task. We look at the account value at the date we selected to divide the asset, and that's the one that gets split. Doesn't necessarily mean that each gets 50%. It's a negotiation. So we have that negotiation take place. A more complicated situation occurs if the party with the account came to the marriage with an account in place. And when that happens, there are three choices as to how we allocate that account between the participant spouse and the non-participant spouse. The first possibility is called tracing. Tracing means you actually trace each contribution that was made to the account during the marriage. You not only trace the contribution, you trace the investment experience of those contributions during the marriage. That is a forensic accountant or forensic financial analyst duty. to trace each of those elements so we know exactly what was accrued during the marriage to be split. The second possibility is called subtraction. In the subtraction method, we take the account at the date of marriage and we subtract it from the date we selected. Let's say we had selected the date of complaint. And that subtraction will give us an amount to divide. But keep in mind, when we use this method, all of the investment experience that is applicable and attributable to the premarital account will fall in that subtraction. So the advisors and the divorcing couple must understand that when the subtraction method is adopted, it will be greater than the tracing method if, in fact, investment experience was positive, attributable to the premarital account. And finally, the coverture method. Now, the definition of coverture means during a marriage. So when we talk about coverture in dividing retirement plan assets, we're talking about something that happened during the marriage. And if we don't want to go through the mathematical situation involved in tracing, we can use what we call the pro rata method in coverture, which means it prorates how long the couple were married and divide that over the time the individual participant spouse was in the plan. Let me give you an example of these three methods in the next slide. Let's say, for argument's sake, the account at the date of marriage was $50,000, and the account at the date we selected for splitting was the date of complaint, and that account was $150,000. Now, obviously, it grew, so for tracing purposes, we're going to have something in between those two numbers. So if a good tracing were done, we might find that 80,000 of the 100 which accrued during the marriage was traced and applicable to the contributions made during the marriage. So for tracing purposes, let's set the tracing number at $80,000. The subtraction method is $150,000 minus $50,000, or $100,000. Remember, the subtraction method was subtracting the date of marriage account from the date of complaint account. Now, we know in this couple's history, they were 10 years in the marriage, but the participant spouse was 20 years in the plan. So when we use coverture, we're going to prorate the account at the date of complaint for the pro rata time that the years of marriage converts to the years in the plan. So 10 over 20 is 50%. 50% of the account at the date of complaint is $75,000. So you can see that depending on the method we select, the amount to be shared could be $25,000, and in other examples as high as $50,000 disparate. And when that happens, we want to make sure that we test each of these methods before we select one, because we don't want somebody going back to court after the division takes place and the numbers are placed in the quadro, where the participant spouse or the non-participant spouse gets less than they would have had a different method been selected. So in our example here, the coverture method is the low one at $75,000, and the subtraction method is the high one at $100,000. Now that does not mean that the subtraction method will win in every case. Some accounts lose money in investments. So in doing the split, of the defined contribution account in this way, my advice is to check all three methods to make sure that there's no question to the divorcing couple and the advisors that the correct one was selected. Let's switch to the defined benefit plan now and go to the next slide. There are two basic methods that are used when we divide a defined benefit plan between two divorcing couples, two people in a divorcing couple. First, we must decide whether the plan to be divided is a cash balance plan or a defined benefit plan. Because if it's a cash balance plan, which, if you recall what I said, a cash balance plan is communicated to participants in accounts. That's very much like defined contribution plans, and we could probably use one of the tracing or subtraction or coverture methods to divide the cash balance account. But if it's a regular defined benefit plan, here we deal with benefits. And there are two basic ways that we can divide those benefits between the participant spouse and the non-participant spouse. The first is called the stream of payments method. That means that at some later date, when the participant spouse will get his benefit or her benefit, we will split that stream of payments between the two parties at that time. The second method is called the separate interest method. Under the separate interest method, we actually calculate the true value of the non-participant spouse's interest in the benefit plan, and we set up a segregated account in the defined benefit plan, and it will be paid at some selected date over the non-participant spouse's life expectancy. Now, these two are very different. Why? Because different things can happen. For example, in the stream of payments method, death could change the way in which we anticipated paying the benefits out. In the separate interest method, if the non-participant spouse dies before the separate interest is payable, then either nothing will happen and the non-participant spouse's family will lose, or a properly drafted quadro will write what happens in the separate interest method. Now, the two last bullets on this slide are very important when it comes to separate interest calculations. Remember when we talked about the valuation offset method, where we actually value the benefit plan and offset it against another asset in the marital estate? We must use actuarial assumptions to calculate the present value of a benefit payable in the future. And sometimes those actuarial assumptions are not as accurate as we would have them be. So, for example, if you remember my very exaggerated example of the two assets in the estate, the home and the plan, and we valued the home at $500,000 and we valued the benefit account at $500,000, what do you think would happen to the participant spouse's family if he collected one check and died? Remember that when we calculated the $500,000 in the benefit plan, we used assumptions such as interest and life expectancy and mortality tables. And these things are general in the industry. So for an individual person who dies after receiving one check and doesn't follow the table that we used in calculating the value of the benefit plan, that means that the true value of the benefit account to the participant was not $500,000. And if there's a family involved, the splitting of those two assets, where the wife keeps the home and the husband keeps the plan, was inaccurate, not fair. So in most cases, I will be a proponent of not using the valuation method. I don't like the idea of having the actual experience unfold differently than the generalized tables that are used in the valuation methods. So I very much favor the Quadro method, and we'll spend a lot of time in the rest of the slides on those orders. So let's talk about some problems we might have with ambiguous PSAs. Let's go to the next slide. If we had a PSA, a property settlement agreement, in the retirement plan section that simply said spouse A gets 50% of spouse B's benefit, and that's all it said, we have what I call a very ambiguous PSA. Why? Because we really don't know, and the plan administrator who is supposed to implement that provision doesn't know whether it's the accrued benefit, the projected benefit, when do we pay it. It's non-specific. And being non-specific causes a major problem when it comes to having to rewrite and go back to a court for a reapproval of an amended PSA. Let me give you an example. Let's presume that the implementation assumed it was to be at the accrued benefit at the date of complaint. And let's say it was $1,000 a month. The participant's spouse had accrued a benefit payable at retirement of $1,000 a month. But if we interpreted the provision to be the projected benefit at retirement, and we're able to project that at $3,000 a month, keeping in mind that the years of marriage was 10 and the years in the plan were 20, that means that the result of implementing an ambiguous PSA in this case, one participant is going to get 1/3 less, because we're splitting 1,000 at the accrued method, but we're splitting 3,000 if it's the projected method. And by the way, if we don't use projected at the date of complaint, but wait till the date of benefit commencement, that 3,000 could be 4,000 or 5,000, which means that if the order went through to the plan administrator as written, the plan administrator will be lost and might make a wrong decision. Might split the 1,000, might split the 3,000, or might split the 4,000 or 5,000, depending on the interpretation. What this means simply is that that PSA was very poorly written, has to be more specific, so that when that provision in the PSA is converted to the orders provisions, the DROS provisions, it will be so specific as to inform the plan administrator exactly what he's supposed to do. Split the 1,000, the 3,000, or at the commencement date, 4,000 or 5,000. Now, there's several very special considerations that people must take into account when we talk about dividing retirement plan assets. So let's look at the next slide. There are many special considerations. Let's begin with the law. The federal law that's applicable to writing quadros and dividing retirement plan assets are contained in, for the most part, IRS and DOL, which is Department of Labor, regulations. So they will apply to every situation across state lines. But fortunately or unfortunately, we also have state laws. So each state has, through the evolution of case law and other regulations that come down through state authorities, different rules that apply to dividing retirement plan assets in a divorce. I'll give you an example. The case law in two states, New York and New Jersey, are very clear that things that happen after a divorce that you would think would not be applicable to a division of a retirement plan asset must be accounted for. So let's stop there and think about that for a minute. You would think that everything about the retirement plan as of the date of the complaint, suppose we pick the date of the complaint as the date of the division, you would think that the account or the benefit as of the date of complaint is the only thing that we split. Well, there are several cases that happened in New York and New Jersey which talked about the non-participant spouse asking for things that happened after the divorce, but were attributable to the divorce years. And the courts decided favorably in favor of that. In New Jersey, the premier case is called Marks, M-A-R-X, and in New York, the premier case is called Majouskas, M-A-J-A-U-S-K-A-S. There are several other states which have their own premier cases, some of them stipulating that nothing after the date of divorce applies, and some of them which followed the Marks and Majouskas case. Next in line for a special consideration is death. We know that when we write an order, we're presuming that nothing will happen between the date we wrote the order and the date that the division will take place. That's not true. Because if one of the spouses dies before or after the commencement of benefits, there's a problem if the order doesn't specify what to do. And if the order is approved and sent back to the plan administrator and death occurs, well, the plan administrator is lost. Either makes a choice that may be wrong and litigatable, or he or she has to go back to court and ask the court for help. What do I do now? The non-participant spouse dies. Does his or her family get a piece? The participant spouse died. Does that change anything with respect to what the non-participant spouse gets? More importantly, what happens if during a divorce and before an order is written, the participant spouse dies? Here too we have a problem. And there is a lot of case law which mostly allows for an order to be written after the death of the participant spouse, even though he or his advisors may not have had input into how the non-participant spouse would get a share. Next, the plan could terminate. The plan we're talking about, let's say we chose the date for splitting the asset at some future date, the plan terminates. Well, if we don't stipulate in the order what happens if the plan terminates, again, the plan administrator is lost, will make a choice that may be inaccurate, or has to go back to court to determine what do I do now, especially when the plan's termination involves a surplus of assets, especially in a defined benefit plan, when that surplus is due to go back either to the adopting employer or to the participant. And we didn't say, does the non-participant spouse share in that surplus? So when we don't have a specificity, we're lost. There could be a new spouse. It's not atypical to find that after a divorce, one or both spouses remarry. In splitting the assets in a divorce, and the date of commencement of the sharing is later and there's a remarriage, there can be no redundancy. The plan can't pay two benefits. The plan can't, because there are rights attributable to the new spouse, and we have to have specificity in the order as to how to treat the new spouse versus the old spouse when the division and sharing takes place. We've got to make sure that there's no redundancy in payment of benefits. Who pays the taxes? These are qualified plans, which means taxes have not yet been paid. Therefore, we have the situation where taxes must be paid, and the typical case is both pay the taxes on their own respective shares. If you remember, I mentioned SERPs, Supplemental Executive Retirement Plans. Those plans are paid after taxes. So the amount going to the non-participant spouse will go after the participant gets his share and pays the tax. So it's a different category of event. It's not unusual to find that divorcing couples, there's a prenuptial agreement. Well, let me make this one comment about prenuptial agreements. Prenuptial agreements can't extinguish the survivor rights of a non-participant spouse. So notwithstanding what the prenup says, the prenup could actually take care of living benefits, and we have to follow that rule. But no attempt to take away the survivor benefit post-death of the participant for the non-participant spouse can be followed from a prenup provision that tries to. So prenups are not 100% applicable to a divorcing couple sharing of retirement benefits. We have a new category of divorcing couple now that we have a Supreme Court case that allows for same-gender marriages. Same-gender marriages are legitimate in the state that the marriage took place, not necessarily the state of the domicile. So same-gender marriages will obviously create same-gender divorces. And if all of the applicability of retirement plan sharing is applicable to same-gender marriages, it will be true for same-gender divorces. It probably increases the business for those involved in divorce, either as an advisor, financial analyst, lawyer, actuary. These same-gender marriages are too early to see how many divorces will occur, but they will evolve. I had mentioned previously that things happen after a divorce that changes the benefits or the accounts of a couple. And those things involve the following four things. Compensation increases, which means that the formula for developing a benefit, which is based on compensation, will change as that compensation increases. Plans are amended to either can't decrease benefits, but they could increase benefits. Some plans have cost of living adjustments, which occur after the divorce. And finally, some things could happen that would change the benefit that wasn't there at the time the order was written. For example, say a participant gets disabled after the divorce, and the disability benefit is greater than the retirement benefit. So here we have four things that could change the benefit payment to the participant spouse after the divorce takes place. Compensation increases, plan changes, cost of living adjustments, and an occurrence such as disability, which will change the benefit structure. If those things happen, state law will control, but somebody has to carefully analyze whether or not one or more of those changes will be shared by the non-participant spouse. So if the benefit to be shared is to take place in the future. If the date we chose was the date of benefit commencement, we have to be prepared to stipulate what happens if in the future the benefit changes from what it was when we wrote the order. And I can tell you that there's lots of case law on this. I told you about New York and New Jersey. There's a lot of case law in other states also that allow for these changes. And the primary reason why the courts agreed with the non-participant spouse suing for a piece of that change is that most benefit formulas use service in the plan. And since a piece of that service in the plan happened during the marriage, a part of the formula is really controlling those changes, whether it's a change in pay, a plan change, a cost of living adjustment, or a disability. That part of that change can be attributed back to the service which accrued during the marriage. You thought that was all of the special considerations. Well, let's look at the next slide. I mentioned that the IRA was visibly absent in the list of retirement plan accounts that I gave you. Well, dividing an IRA is a little different than dividing qualified plans. Why? Because IRA divisions don't require quadros. All that is needed is a court order given to the custodian of the IRA, who must follow that court order to split the IRA when the IRA is to be divided. So even though that court order looks like and tastes like a quadro, it does not need to be and contain all of the elements of the quadro that are required by state or federal law. So dividing an IRA is a little simpler. Many defined contribution plans allow for loans. As a matter of fact, it's about 85% of the defined contribution plans in the world, 401k, 403b, profit-sharing plans, allow for participants to take a loan. And when a loan is taken and still exists at the time the marriage breaks up, we have to deliberate who enjoyed the loan while it was taken in order for us to stipulate in the quadro how that loan will be shared in terms of repayment. So loans can't be ignored, and it's got to be a question asked when the quadro preparer does prepare that document as to who will take care of the loan repayment. We have categorized military and public plans in a different area of divorce. Military plans have their own rules, and only specialists in military plans should be engaged to handle splitting of military plans. Navy, Army, all different, and they have their own specificity with respect to who gets what and when, and only military divorce specialists should be used in those cases. Public plans are a little different. Public plans do mimic private sector qualified plans. So when we talk about a teacher or a policeman or a fireman getting divorced, those are public plans. They're public plans usually in state-run retirement funds, and even though a quadro isn't needed, a DRO is. Very similar in language and can be handled by the same person who would handle a private sector divorce, splitting of a qualified plan. How do we handle Social Security? Very simply, if both participants have their own Social Security benefit, typically Social Security is not an element to consider in dividing retirement plan assets. However, if one does and one doesn't, and that's possible because railroad employees and other particular public type of employees don't participate in Social Security, there has to be a consideration of one having Social Security and the other having a substitute form of Social Security in their plan. And we have to take a look at what that difference is in splitting all of the retirement plan assets. We also have to consider in Social Security there is what is called the divorced spouse benefit. We have to make sure our clients understand that divorces that occur after 10 years of marriage, if a participant has been married for more than 10 years and remains unmarried when the Social Security participant gets his or her share, that divorced participant is entitled to his or her 50%. So Social Security unto itself has a benefit for divorced spouses, and it should be part of all discussion, not necessarily changing the numbers, but it should be something that should be considered in all discussions with divorcing couples. Non-qualified plans, I mentioned before, the only consideration is who pays the taxes, and typically it's the participant spouse who pays the tax, and the non-participant spouse should understand that once that tax is out, he or she does not have to pay the tax, nor will they get a benefit of having the participant. They have to consider that the tax has been taken out already. Bargaining agreements have their own rules with respect to divorce, and that takes care of our union plan special consideration. We have to read the bargaining agreement to determine if and when something must be done in our documents to conform and comply with the bargaining agreement. One or both parties could become bankrupt. Now, we know that in the bankruptcy rules in the law, most qualified plans are not attackable by creditors. So in quadros, it's clear in the law that there is no discharge of a debt in a quadro occurring because of a bankruptcy. So if the participant's account is to be split with what's called the alternate payee, that non-participant spouse is called the alternate payee, that will take place notwithstanding the bankruptcy of the participant. In fact, if the alternate payee goes bankrupt before the payment of his or her share takes place, it is protected. However, if the plan asset has been distributed and a bankruptcy takes place, it is subject to attack by the creditors. So there is a difference as to whether the money is still in the plan versus it's out of the plan. Many states are what are called community property states. Different rules. The basic rule of a community property state is 1/2 of each asset in a marital estate automatically belongs to each spouse. So when we come to divide retirement plans in a community property state, 1/2 of the plan asset already belongs to the non-participant spouse. So when we consider how to split and divide the rest, we may not have to divide much, but it has to be considered because 1/2 already belongs to that particular spouse. Unlike a non-community property state where nothing belongs to the non-participant spouse unless it's specified in the quadro. Community property states are a special animal and need special consideration when we come to writing quadros. The mandates we talked about, I talked about New York and New Jersey. There are lots of state mandates that have either evolved from case law or from just a rule or regulation put forth by a state statute. Sometimes a plan is funded with a life insurance contract or an annuity contract. And when you get to divide typical plan assets, the typical division anticipates that there's going to be cash. Now, if we have contracts which one or both parties don't want to dissolve or surrender, particularly life insurance when a health situation has changed. Well, when we split the asset, part of that asset distribution in the division might include a contract and not necessarily a cash. And when it does, we have to be very careful with respect to where it goes. As you may know, life insurance contracts are not allowed to be included in IRAs. And a lot of these cash payments to alternate payees are rolled over to IRAs so that the non-participant spouse does not pay immediate taxation. But when we have a life insurance contract, we have to go through the various ways in which that contract can come out of the plan with the best tax result possible. It can't go to an IRA. However, an annuity contract can go to an IRA. So if part of the distribution is in an annuity contract, we can put it in the IRA. Those are the special considerations that I would have you deliberate in a divorce. I mean, more importantly is the rollover situation. I mean, several large rollovers take place from these divorces, and financial analysts are very important in terms of making sure it goes to the right place and has the right investment objectives satisfied. So let's go to the next slide and go over the process that is needed to implement a QDRO. And there are three segments that must be adhered to. Number one, a DRO, before it becomes a QDRO, is first approved by each party. It's written either by a lawyer or an actuary or some other individual well-versed in writing QDROs. And the terms of that DRO must be approved by each party and their counsel. When that's done, that DRO is sent on to the plan's administrator, because the plan administrator is the one that must satisfy him or herself that they can do what it says in the QDRO's terms. Does it satisfy the plan's terms? Can I get it done? Is it legal in my eyes? That DRO becomes a QDRO when the plan administrator says, I have qualified it, and now I will send it to the court, or ask the parties and their counsel to send it to the court, so the court returns it to me, the plan administrator, to implement what the provisions of the QDRO says. That's mostly what I wanted to say to you today, but I want to show you something in the next slide. Some final special considerations, and these are things that I've covered in the booklet I've written. My experience was in the 25 years that I've been doing retirement plan asset splits for divorcing couples and their advisors, was that most are either ill-advised or don't know all of the possibilities for splitting that asset. So I thought it would be a good idea to draft a booklet which is called Dividing Retirement Plan Assets in a Divorce. And some of the things that I didn't mention in the previous slides that I should mention now are important and covered in that booklet. Number one, what happens when we divide an account and it's to be paid at some future date? Well, we have to specify who's going to invest that account. It's in a 401k plan. 401k plan, if we have a one-participant plan, and that one participant is the trustee of the plan, and that participant is the one getting divorced, we certainly don't want that participant to be responsible to invest the assets of the separate account that we just divided for the non-participant spouse. So we have to guard against having one participant invest the asset of the other, or else we'll find ourselves in litigation. Second special consideration in the booklet is what's called the Child and Spousal Support quadro. Sometimes quadros don't necessarily take care of the non-participant spouse alone. They take care of a child support or spousal support in alimony. So quadros have a special deliberation in terms of those categories. Next, also covered in the booklet, beneficiary designations. We have to advise our clients to change the beneficiary designations of the non-retirement plan assets in the marital estate. Life insurance contracts, annuity contracts have beneficiary designations. And I've seen happen too many times that we forgot to change the beneficiary, the participant dies, the participant had expected that his life insurance would go to his children and his second wife, and he forgot to change the beneficiary designation in the non-retirement plan asset, and the payment to that beneficiary must be paid to the named beneficiary, and if it was kept at the prior spouse, nothing can be done. And finally, there is what's called a reverse quadro. A reverse quadro is written when the non-participant spouse rejects sharing in the participant spouse's account or benefit. A quadro should be written as a reverse to stipulate in finality that the non-participant spouse will get nothing. Final slide, when we put it up, and I want to mention 3 very common mistakes that we sort of touched on in this presentation when writing a quadro and taking care of splitting the assets. First, ambiguous PSAs. I think you saw from the example I gave you that the ambiguity in that PSA was something that caused significant disparity between what should have been paid and what could have been paid to the non-participant spouse versus what the participant spouse should give up. The PSA should be very specific. Second, when it comes to defined contribution plans and there is an account that was brought to the marriage, we have to deliberate which of the 3 methods to use to divide the asset. Should we trace the contributions and the investment experience during the marriage? Should we just subtract one account from another? Or should we use the coverture fraction? That's the common mistake I see in the defined contribution plan area. And finally, defined benefit plans. Defined benefit plans have to deliberate whether we will split the benefit now or later. And I can tell you from my experience that it is not unusual for a non-participant spouse to wait until later to find that his or her share exceeds what would have been paid had we distributed the share at the time of the complaint or the divorce. So those are the 3 mistakes I see mostly in the 25 years. I've covered all of them in the booklet. If anyone has any questions after you listen to this recording, you can always get to me from the website divorcepensionrights.com. The booklet is available there or on Amazon.com. And I thank you for listening. And hopefully these special treatment of division of retirement plan assets will be helpful in your analyzing the finances of your divorcing couple clients. Thank you again. Back to you, Jessica.